To discuss this further, I'm being joined by a lawyer, Evans Ufeli. Hello, Evans. Thank you for joining us at this time. So, Evans, tell us, how significant is the role of intent in proving corruption charges in this case, particularly regarding Sirika's alleged fraudulent awarding of contracts to family members and associates?
Well, at the level of prosecution, at the level of arraignment, everything still lies in the realm of allegation. The charge preferred against him is to enable him take his plea, which he has done today. He has pleaded not guilty, and he has been granted bail according to law. But then the court will continue prosecution. The prosecution is ready, and the defense appears to be ready for this case. So largely, the prosecution, which is the EFCC, will have to prove the case beyond reasonable doubt, and that is the standard of law. The allegations are quite onerous. It appears the EFCC have gathered evidence to this effect. So one will look at the process of proceedings and how this will go. The primary offender, the secondary offenders, and all that have been properly captured in the charge preferred against the defendants. So it is one that must be followed keenly so that we'll get to a conclusion of the matter, to know who did what, when, and how that we have a Nigerian air that we could not understand exactly how the processes went. See, it is trial that will reveal who did the wrong thing, who should be punished according to law, and generally those who will be brought to book by virtue of this contractual engagement.
All right. Now, in proving the case beyond any reasonable doubt, are there any potential conflicts of interest that could impact the impartiality of the judge or the fairness of the trial, given that, given Sirika's previous position within the government?
No, I don't think so. I don't think there's going to be impartiality or any condition or conflict of interest that will impede judgment. I mean, the judge in question have no relationship with Sirika. The court itself is constituted to do justice dispassionately, to look at cases dispassionately. And more importantly, Nigerians should watch. Nigerians should be vigilant and follow up this case in such a way that will get to a logical conclusion. In the eyes of the law and from the standpoint of a bystander, there is nothing that is sought or obstructing, or that would create a situation where justice would not be seen here, except there are issues we don't know about. But as it stands, as the case is constituted right now, there's a tendency that the EFCC will do it best, put in their best. The defendant is also, by Section 35 of the 1999 Constitution, have the constitutional safeguard of being given adequate time and facility to prepare their defense. Okay, so everything is within the ambit of law as we speak.
Okay, so talking about it being within the ambits of the law, Evans, what legal avenues are available to the defense if they believe that the bail conditions set by the court are unduly restrictive or disproportionate to the alleged offenses?
Well, the legal remedy open to them is to bring a motion before the same court to ask for variation. And that if they have cogent reasons and they have a good evidence to show that perhaps the bail condition is one that is out of reach, then the court will consider to vary the condition. That is what they have before the law. Their lawyers know what to do. Is to come before the same court with a motion. And that motion will be heard. A motion on notice, which the EFCC will put on notice to that effect. They may decide to file a counter affidavit also to argue why the bail condition should remain the way it is. But the legal remedy is to bring a motion to ask the court to vary the bail condition on the basis that it is stringent or it is out of reach.
Okay. All right. Well, thank you so much, Evans, for taking time out to speak to us.
Thank you very much.